We're going to start early, as my dad used to say. Early is on time is late, and late is unacceptable. We're going to begin and call this meeting to order for the Senate Public Safety Committee. Thank you for being here on a Thursday afternoon when we're not in legislative session on Friday. We're going to try. We've got a few bills that I think are already pretty quick, and we've got one that's going to take a little bit more time. So if you are here to speak on a bill, I'm going to ask you to be brief for the first few, and we're going to get some people up and down. But to do the most important thing we do to start out would be to have a word of prayer. And without any initial time to ask him, I'm just going to ask our chairman, Rick Williams, over there from the Retirement Committee to maybe give us a word.
Be glad to. Dear Heavenly Father, thank you for this many blessings you've bestowed upon each and every one of us, dear Lord. Thank you for another day. Thank you for the opportunity to serve in our capacity to the great state of Georgia. Please lead us, guide us, direct us as thy will be done. In thy name we pray, amen.
Amen. Thank you. Okay, we're going to jump in and get started here. We're going to start first with House Bill 541. Representative Lumsden, what rank were you in the GSP?
Well, sir, I was a master trooper.
Master trooper, all right.
If you put it in military parlance, I guess that's still an enlisted man as opposed to the officer corps.
I like the master trooper, though. That sounds pretty good. All right. Sign-up sheet up front. If you don't fill out all the boxes, you don't get to talk. That's my rule, okay? Thank you. All right, go ahead and take us away here. It's a pretty simple bill.
All right, sir. Mr. Chairman, members of the committee, I bring to you House Bill 541, LC number 393869S. This combines two House bills which are dealing with a similar subject matter. In the first bill, it deals with a stranded vehicle on the shoulder of the road, deals with action that a motorist approaching that vehicle should take. Basically, it provides slow down, pass on the left if safe to do so at a reduced speed, if not to reduce your speed to stay behind the vehicle until such time as it is safe to do so. The other one deals with a postal carrier or postal service vehicles. As you know, a postal service vehicle travels in a slightly irregular manner, stop and go, slower speeds. The same thing applies to the postal service vehicle as would apply to the vehicle on the shoulder of the road. The key to both of them is that they have to have flashing lights in place.
Pretty straightforward, I think, modeling some of the things we've done in the past. Are there questions from the committee members on House Bill 541? Seeing none, what is the will of the committee? Motion to pass from Senator Williams, second from Senator Robertson. Any further discussion from the committee members? Seeing none, all those in favor, please say aye. Aye. All opposed, please say no. Passes unanimously. And who's carrying this bill?
Mr. Robertson is carrying this bill.
Oh, thank goodness. Whew.
Senator Robertson.
Got nervous. Reconsider.
You said you would for me. I asked you the other day. Do you not remember?
Yeah. All right. Thank you very much.
All right.
Safe travels on the road.
Thank you, sir.
All right. Next up, we're at Chairman Corbett. There we go. Thank you for all the great work you do in your committee. It's always a pleasure as we send things back and forth to our committees to work on a great way to serve the people. So, Mr. Chairman, thank you for coming forward today with House Bill 120.
Well, thank you, Mr. Chairman. It is always a pleasure for me to present to your committee. Y'all do fine work as well. I bring before you today House Bill 120, LC 393852S. Is that what we have in our package?
Gotcha. Yep, go right ahead, sir.
And just like the previous bill, what we've done is combined two House bills here, House Bill 120 and House Bill 167. The 167, I'll speak to it first, and it has to do with child support and being able to get a limited driving permit. You know, this allows customers that may have fallen behind on child support to drive back and forth to work so that they can earn wages to pay and support their kids. If the customer's not working, you know, they cannot pay their child support. There's currently no opposition. There's not an option for this service from DDS right now. So they don't have an option to give them a limited driving permit at the discretion of a judge. The judge has the discretion to allow the customer to receive a limited permit, and as of January 1st, 2023, there are 119,000 child support suspensions in effect. So quite a few. And the purpose of that bill is just to give the judge the discretion where they can go to work to home, limited only, and they can revoke it. It's at their discretion if they violate first offenders only. And then the other part, House Bill 120, was for a DUI drug offenses. And this is some cleanup language from 2020, House Bill 799. It removed the language that prohibited someone charged with DUI drugs from receiving an early reinstatement or limited driving permit. However, the permissive language was omitted. So what we're doing here is they're doing it now, but they would like to have it codified that they have that permission to do so. And that was what the other part of the bill does. And I'll try to answer any questions if there are any.
Thank you, Chairman Corbett. I think this is a great bill, and while I have little grace for someone not making their child support payments, the last thing we want to do is not let them get to work in order to make some money to make those child support payments, and certainly adding the permissive language back is a no-brainer, I would think. Are there questions of committee members? Pretty straightforward bill.
Where's that second part? The part about drugs, DUI?
That is in the first part of the bill. You'll see the underlined section,
Is that line 30?
line 30, G. It's just adding that back in.
That's correct.
It's not very descriptive because it's just adding back in. I actually struggle with that for a moment as well. Okay.
Yeah.
All right. Other questions from the committee members? We do have one person signed up to talk. Mr. Chairman, if you just take a seat for a moment, we've got Jill Travis. If you'll come up and give us a moment of your thoughts.
Yes, good afternoon, Chairman and members of the committee. Thank you for hearing from me today. I'm with the Georgia Association of Criminal Defense Lawyers. I worked well with Representative Montaham and Representative Corbett to get a change made to this bill, but unfortunately, it doesn't look like it made it into this this draft. And let me explain what it is that we were asking for and tell you what it is that we would like to do. So we are in favor of the bill. We like the idea of people getting their driver's license, having a limited driving permit for purposes of when they've been suspended for non-payment of child support. But unfortunately, the giveth and the taketh away have the same language, and there's no distinguishing that. So today, I get a limited driving permit to drive to work because I have been suspended for non-payment of child support. I start working, and then you have to imagine that there has to be some period of time that I get a break to try to pay the child support before you suspend me, because the language that's used on line, page 4 of your bill at line 76 to 78 says the court or the Department of Human Services, which is responsible for enforcing orders for child support, that the permittee has demonstrated that is not in compliance, I think is what your language is not in compliance, which is the same language that gives them the right to give the permit. So we had worked out with the Department of Human
Driver Services?
DDS and DHS, both agencies, we ran this language by them. They all agreed that if I think it's going to be around line 76 of your bill, after the word permittee, has demonstrated a lack of good faith by continued noncompliance is the language that we've asked to be added, because you have to have some, they have to have some chance to pay the child support, and then we have to have some subsequent action. So the language as drafted in the version that came over to you that's in the bill didn't have that in there. We did not notice it on the House side, but we did notice it once we got to the Senate side. So once again, on line around 77 where it says permittee, if you took out is not in compliance and replaced that with has demonstrated a lack of good faith by continued noncompliance, that would be our request.
Thank you, Jill. I appreciate that. Many of us met earlier to discuss this, and while I always respect your input and your opinion, I don't believe it's necessary. I believe the language covers it, and the folks that we've talked to agree with that. So I'm not going to accept that as an amendment on this, but I do appreciate your testimony.
I appreciate it. I was told that when it's broken next year, we can come back and fix it, and maybe that will be the circumstance.
Likely not, but thank you so much for coming. All right, what is the will of the committee?
Motion.
Motion to pass from Senator Robertson. I got a second from Senator Goodman. Any further discussion from the committee members? Seeing none, all those in favor, please say aye. Aye. All opposed, please say no. Passed unanimously. Congratulations, Mr. Chairman. And we will get that out, and 120 is being carried by.
I believe the chairman of the committee agreed to do
All right, that's right. I'm just making sure it was me. Thank you. All right, we're going to move on. Next, we have House Bill 175, and I know we've repurposed that a little bit, but originally we had Representative Warren Daniel, but I think we have a change to that, don't we now, Mr. Representative? Yes, sir. All right, come on down.
Thank
Now,
you, Mr. Chairman.
Is this your first time in front of the Public Safety Committee?
Yes, sir, it is.
Okay.
It's truly an honor to
Could
be here.
First bill?
Yes, sir.
Oh.
Well, it's I'm
Freshman
working
bill.
with the good chairman here, getting this done, and if it helps any, I'm a part of the great Columbus delegation with Senator Randy Robinson. So
Yeah, overruled.
And you were doing so well.
I was doing well. Well, I tried. Well, Mr. Chairman, thank you and the committee for your time and working this late evening to do the work for the people of Georgia. I greatly appreciate your presence. We have before us House Bill 175, and it is truly my honor to carry this bill and speak on behalf of our Commissioner of Agriculture, as well as our Public Service Commissioners, and as well as Kappa Alpha Psi Fraternity and Alpha Phi Alpha Fraternity. Real quick, let's kind of work backwards here. If you start at Section 2, as it relates to Kappa Alpha Psi and Alpha Phi Alpha, both organizations already have state tags. We're just instituting the revenue sharing aspect of it. They've met the 1,000 tag threshold, and we just need to codify the language. So we've done this for many of our tags before. Now, working back to Section 1, we have some constitutional officers that are good friends of ours who are not happy by the fact that they can't have a state tag. So we want them to feel like they're part of the club. So we would like to add the Commissioner of Agriculture as well as the Public Service Commissioners to the list of individuals that already receive identified state tags, as you see in Section 1. So if you see the underlined part was the portion that we added.
And we added to this, want to thank the folks from the Department of Revenue. I see them over here in the crowd. We actually decided to just put all constitutional officers in there for statewide, so that would be, as outlined, the governor, lieutenant governor, secretary of state, attorney general, state school superintendent, commissioner of insurance, agriculture, labor, and public service commissioner.
Yes, sir.
Just to give them all the equal amount of attention for those that might want to get a plate.
Yes, sir.
Please note to everybody listening, we do have to pay for those plates.
Yes,
and they
we
are more expensive than getting a regular one.
And
Great.
the state benefits because we're contributing to the general fund.
That's right.
Yes, sir.
That's a great way of putting it. All right. Questions for the bill's new author? Question from Senator Dugan.
Thank you, and I hope that you'd be excited about adding one more for disabled vets that didn't make it out of the Senate in time. It's what it does is for those that are disabled, but their disability is not as visible as others. It allows them to have the perks of the disabled tag without the disabled tag.
You know, sir, I can't think of an amendment that's more worthy than that. We are big
Thank you.
appreciation for our veterans for what they have done for us and our country. So
Yeah.
we certainly accept that.
I promise it's not a poison pill.
Yes, sir.
Okay. Thank you.
Other questions from the committee members? All right, we'll take a motion, then we'll see if there are any amendments on that. Do I have a motion on this bill?
Move to pass.
Motion to pass from Senator Dugan, a second from Senator Goodman. Are there any amendments?
Other than what I'm going to put on there when it gets on the floor, because I don't have the draft in front of me.
Okay, there'll be no amendments today. No further discussion. We'll call a vote. All those in favor, please say aye.
Aye.
All opposed, please say no. Okay. All right. You got a unanimous passage, and
Thank you,
who's carrying
sir.
this bill for you in the Senate?
Yes, sir. Well, I assume it's you, Mr. Chairman. Is it Mr. Chairman?
Probably Nikki, who had
Well, Nikki Merritt. We can ask Senator Merritt if that's okay.
Whoever you'd like to, just if you would let us know, maybe first thing tomorrow morning.
Yes,
So
sir.
we can get that in on the roll.
Yes, sir.
That'd be
We'll
great.
get
Thank
that
you. Great
confirmed
job
for
on
you.
your first presentation.
Thank you. Thank you, sir.
All right.
Thank you, Mr. Chairman.
You got off pretty easy, too. I just want to let you know. So. It's late on Thursday, so. Okay. All right, next up, very excited about a very, very special bill here. We're going to have House Bill 188 next. And I'm going to ask Representative Saines if you'll come to the podium, sir. I want to thank you for your great work on this bill, as well as all the work we've been doing to clean up a little bit of the language where we needed to make a little adjustment today. I also want to give a big shout out and thanks to Jenna Dolday, who's our legislative counsel, as well as Holly and others who have helped do this. So I'm going to turn this over to you, sir.
Thank you, Mr. Chairman, and I do appreciate the quick turnaround in the review from this committee in perfecting a crucial piece of legislation to keep Georgia families safe. I won't speak specific lines because does the committee have the Senate sub in
We
front
have
of them?
LC 480924S. Is that what you have?
I do.
Okay, perfect.
So based on that, I'll give a brief overview. This was previously assigned to Senate Judiciary. I'm very glad to be before Public Safety this year. The premise of the overall legislation is to be a response to Park v. State in 2018. The Supreme Court of Georgia made it to where Georgia sheriffs were unable to do a GPS monitor for those who are dangerous sexual predators. Those are the level 3s out of the 1 through 3 SORB leveling, most likely to reoffend. It was previously they're able to do that just by them being on the registry. The courts decided that it would be unlawful unless they were in some kind of state custody. So lifetime probation was a recommendation of a Senate study committee on that issue, and it is within this bill. What this would do would be looking at 13 felony sexual offenses, which you can find starting on line 44. And if an individual is twice convicted of one of those, of that menu of 13, they would then qualify. They would then be required to have a concurrent lifetime sentence of probation added to that second sentence. That would enable the Department of Community Supervision to have a GPS monitor on those individuals. Then more recently, with Merriam's law provisions added to the bill, which was an unfortunate incident that happened in Atlanta that many individuals are aware of. Her family is here today, and they've been great advocates. We've added what would have helped her case, and which we hope would help families prevent victims in the future, which is looking at the time in between a offender getting out on probation and waiting to be leveled. Unfortunately, due to the constraints of SORB, the huge backlog COVID has caused, and truly the psychological assessment that our state conducts versus others who just look at criminology patterns and sentencing history. This is truly a psychological assessment on risk of reoffense. We want to make sure no one falls in the gap. So what this will do, and it starts on line 401, would be to ensure that if a individual has one felony level conviction prior to the sentence they're serving, and so that this would be their second sentence that they're out on probation for, they would be required until they're leveled to be on a GPS monitor device. If they're at that point leveled and a level 3, they would stay on a GPS monitoring device, and after and continue. If they're leveled and not a level 3, it's up to the Department of Community Supervision's probation officer to make the judgment if that individual should be on a GPS monitor. That's a general overview of the bill. It is lengthy, but I would emphasize that the majority, after the 13 sexual offenses are termed, you go into each code section to apply that concurrent sentence.
Thank you very much, Representative. Again, I've served here for 13 years and worked on a lot of bills with a lot of people. These are some of the most important ones that tie back to such an impactful story. So we're going to hear a little bit of testimony from folks and then ask you to come back up at the end to close us out. But we have questions before the author. Oh, we have a question from Senator Jackson.
Thank you, Mr. Chairman. I want to begin by saying I'm deeply grieved by the vicious and traumatic events that occurred to Miriam, and I'm grateful for her family for the advocacy they've done. But Mr. Saines, what you've done is you tell me that this would have prevented this would have prevented such a horrible tragedy if the man who did this had been leveled and put on a GPS monitor. And I think we have a responsibility to the family to make sure that that's true. So can you walk me through how leveling and putting him on a GPS monitor, anyone, is actually going to prevent them from taking such heinous actions? Can you just...
Sure. And I don't want to overstate the bill or specifically Miriam's case. I would say that Miriam's family assessed her situation, and this was one of a few, and we hope that there will be multiple other policy initiatives that go forward, but this is one of a few that her family and friends in partnership with some policy experts highlighted as something that could have been a preventative measure, and the Senate's own study committee did make a determination that GPS monitoring is one of the leading ways to prevent sexual offenders from reoffending, because it allows for the Department of Community Supervision or any supervising authority to look at the patterns of behaviors, look at if, in this case, there was a stalking, and highlight that to that officer so that that officer can take preventative measures prior to an offense being conducted.
Other questions? I've got one from Senator Payne.
Thank you. GPS monitoring, isn't it true that also prevents a lot of things happening because that the seventh knows that they're being tracked, and so therefore it curves their behavior on the front end as well?
I would agree with your assessment on that.
All right. Thank you.
Other questions? All right. We're going to call some folks up here. Jill Travis and Carlos Rodriguez.
Because there's just one microphone, we're going to talk serially as opposed to trying to share the microphone.
All right.
Good afternoon, members of the committee. My name is Jill Travis. I'm with the Georgia Association of Criminal Defense Lawyers. I have been working with Representative Saines on this bill for many years, and we do have some concerns about it. Unfortunately, although we've been working together for quite some time, I didn't have the substitute that you're discussing right now, so I don't want to say anything that's not in your substitute, so bear with me for my little bit of unpreparedness. But when things get done at the last minute, which I know is often the case at this place, it's difficult to keep up. Let me start with just acknowledging how horrible we feel about Miriam's death. And many in the community have suffered along with this tragedy. Unfortunately, I think we're using this bill to some degree to exploit that tragedy. The name of this bill for the longest of time has been Georgia's Dangerous Sexual Predator Prevention Act, but now it's become Miriam's Law out of political convenience. The idea behind this law is that we're going to take the names of crimes and we're going to make them be life sentences. We're not going to take into circumstances of the nature of the offense and the circumstances of the person. We're just going to give a life sentence. As Representative Saines mentioned, this bill was vetted by the Judiciary Committee last year. And one of the things that was a struggle was, you'll find in the bill, and because this is a new number, I don't know the page and line numbers, but let me tell you that there are certain crimes in our law that already require life punishment for a second offense: kidnapping somebody under the age of 14, rape, aggravated sodomy, aggravated sexual battery. But there are many crimes that don't require a life sentence. And the Senate report said that the General Assembly should consider giving discretion to the judges to impose a life sentence and to pose lifetime monitoring. I could read off the line numbers to you if it would be of interest, but it's the wrong bill, so I'm not sure that I can do that, and I'm not sure what the appetite is, but I'll just give you an example on the bill that you have. It is, if I'm looking at page 4, this is aggravated assault with the intent to rape. Starting at line 66, it requires that the judge, and I'm looking at line 67, shall be punished by imprisonment for life and shall impose the Representative Saines gave me one.
Oh, so you're reading off the one?
I'm reading off the one now, but my notes don't line up, so I'm sorry. That that the words shall on line 67 and the words shall on line 69 that require the imposition of mandatory life sentence and require the imposition of a monitoring device. Those things we would ask to be discretionary. There certainly are instances where the law already requires that to be mandatory, but we would ask that they be discretionary, at least in the offenses that don't have those kinds of punishments involved. That would be aggravated assault with the intent to rape, trafficking someone for sexual servitude when they're an adult, statutory rape, child molestation, enticing a child for indecent purposes, which can be done in a sting operation, improper sexual contact, incest, and sexual exploitation, which can be possession of child pornography. The difficulty with this subject is this is not an easy topic. There is not a constituency out there that says any kinds of these offenses are, it's not like somebody that's an addict necessarily with drugs, but that may garner some sympathy. I know that there is no sympathy for these situations, but you have to look at the whole picture, not just the name of the crime, which can be manipulated to some degree by what the charging decisions are of the prosecutor. The other part of, and I think also a little bit of the background of this bill was presented in subcommittee in the House. There was testimony on it. Representative Saines says he was going to be making some changes. There was no vote in subcommittee, and then it went to full committee, and it was not on the calendar. It was called at the last minute, and there was no testimony taken. So I do seriously appreciate the ability to talk about this bill. I just wish I would have known a little bit more about what it was going to say. So I'm going to direct your attention to I'm wrapping it up, sir, and I'm going to turn it over to Mr. Rodriguez, to page 17, which is allegedly the area of the bill that deals with the electronic monitoring of people. The difficulty with your language here is you're allowing a community supervision officer to make the decision as to whether somebody should be wearing an electronic device without any due process, without any decision making, or without any background information in terms of their whether the person should be required to wear an electronic monitoring device.
Just to make sure we're talking about a person who's on probation, who is just in jail, who was convicted of crimes, right?
This is a person that
Yes.
this is a person that's not necessarily on probation. It could be somebody that's in prison that's getting out. The language says, prior to receiving a risk assessment, the person is fitted with an electronic device if they meet certain criteria.
Yeah, but to say they didn't have due process is just absolutely wrong. They got due process when they went through the system the first time and stood before a judge and got prosecuted and found guilty.
I think the appellate courts will be deciding that. I'll let Mr. Rodriguez follow me.
Good afternoon. Thank you, Mr. Chairman. Thank you to the committee. I appreciate y'all's attention to this bill. Just to piggyback off of what Ms. Travis was saying, and my name is Carlos Rodriguez. I'm a practicing attorney, criminal defense attorney out of Marietta. I've actually had the opportunity to litigate in this space and successfully challenged some of the SORB's decisions in the Superior Court here in Fulton County. This is a highly litigated area of the law. Okay? It is a very complicated area of the law, and this bill touches upon a lot of different statutes. And it is true that in its inception, this bill followed the Park decision. It was decided in March the 4th of 2019. And the holding there was that GPS monitoring is a warrantless search of individuals who they must pay for that warrantless search, and they're required to do it for the rest of their life, even beyond the time of their sentence. And the court held that that is unreasonable. Okay? And the due process concerns of having a community supervision officer be the one to decide whether they, the individual that's being released from custody, should be wearing an ankle monitor. There are due process implications because a Superior Court judge at sentencing did not require GPS monitoring. And so by adding this requirement of a GPS monitor, which is an unreasonable warrantless search without court approval, at the whim of a Department of Community Supervision officer who is not even SORB, affiliated with the Sex Offender Registry Review Board, there are due process concerns there. Fourth Amendment concerns as were addressed in Park. And I'll just tell you very confidently, if this bill is passed as written, it will be reversed. I mean, there's just no doubt about it. Putting the authority in a probation officer to decide if someone that is not a repeat offender, right? Look at the conditions. Not a repeat offender, but just in the opinion of a community supervision officer, this person should have an ankle monitor without any notice to the individual beforehand. And he's required to pay. So if we unpack that, the requirement to pay is in direct contrast, direct conflict with current statutes, 42-8-34, E3C, where an individual that has been released from confinement and within the preceding 12 months was incarcerated for more than 30 days, there is a legal presumption that that person is indigent and a financial hardship and unable to pay for the costs associated with their sentence. Who will pay for an ankle monitor for someone that has been in prison for 10 years? No ability to get a job. Who will pay for that? And it's putting that responsibility and burden on the individual that's being released because SORB didn't do their job, right? If SORB does not meet its statutory requirements to classify an individual within the time limits prescribed in the statute, SORB, the state, they don't pay for the ankle monitor. The individual does because they didn't meet the statutory time limits. This bill contemplates SORB not doing their job. I would ask this committee to please look closely at a bill that is essentially an attempt to perform surgery with a chainsaw. It's not sufficiently precise, thoughtful in consideration for the rights of the individuals, because they still do have rights. And the Supreme Court will acknowledge that. They did in Park, and they will again. Thank you.
Thank you for your testimony and opinion, even if I disagree with pretty much all of it. All right. Next up, Mr. Mike Mitchell with the Georgia Sheriff's Association.
Thank you, Mr. Chairman. Committee members, good afternoon. Pleasure to be with you this afternoon. Thank you for the opportunity for the Sheriff's Association to be here. Again, Mike Mitchell, and today I speak with one voice from 159 sheriffs across the state of Georgia, and we offer our wholehearted support for House Bill 188, and we applaud Representative Saints for bringing this bill. We believe it is a huge step forward in enhancing public safety here in the state of Georgia. 37,235 are the number of registered sex offenders here in the state of Georgia, and at some point in time, the sheriffs here in the state of Georgia have contact with those 37,235 individuals. They register new offenders, they update the registry, they enforce proximity requirements, they search for absconders, and they maintain the public registry, sex offender registry in the counties that they serve. 300 sheriffs, deputy sheriffs, investigators, and civilian personnel here in the state of Georgia work with the sex offender registry. The Georgia Sheriff's Association annually conducts 2 sex offender classes, basic sex offender classes for sheriff's offices here in the state. We have sex offender management conferences here in the state of Georgia for our sheriff's offices, which typically have 300 attendees between the 3 trainings that we offer annually. And we also have a sex offender registry task force that's comprised of members from our various sheriff's offices here in the state of Georgia. So the sheriffs have a very vested interest in the sex offender registry here in the state of Georgia, and sheriffs have the exclusive responsibility for enforcing the sex offender statutes here in the state of Georgia in the counties that they serve. So again, we offer full support for this particular piece of legislation and would ask for the committee's favorable consideration. Thank you.
Thank you for your testimony. Questions for Mike? Seeing none, thank you. I am going to recognize our Vice Chairman, Senator Robertson, because of things that have been said. We actually studied this issue in a study committee, and I think he'll bring some context.
Yeah, and I guess, I was looking for Representative Sainz, yeah. And you referenced this earlier, and I just want to be clear and to the chairman. Back in 2019, and Representative Sainz referenced this, a study committee was held by the Georgia State Senate. Senator Renee Utterman at the time chaired that. On that committee was our chairman here, myself, Senator Kay Kirkpatrick, and the late, great Senator Greg Kirk. And a lot of the testimony that we received was on the park, dealing with the park decision coming out. And you said you have looked at the study committee and used it as you developed this piece of legislation. And I just want to point out that those who said a unanimous opinion that came out of the Supreme Court of Georgia, that was authored by Chief Justice Melton, it did state the unconstitutionality of the processes surrounding Park. But I'm wondering, and I believe I know the answer to this, in this, they also said that the opinion identified statutes in other states that authorize a lifelong GPS search of persons classified as sexually dangerous predators that have passed constitutional muster. Is that one of the parts of this that you have took into consideration in the development of this legislation?
The Senate Study Committee was the initiating factor in developing the legislation, and I would add, in terms of something that is frequently mentioned in terms of the distinction between the Senate Study Committee mentioning the ability for a judge to make that determination. We do have judicial discretion here in though it is a requirement in consistency upon that second offense, which is a very tailored way of looking at that, at who's required to have that lifelong monitoring. It looks at a criminology pattern that we know is about 98% going to be leveled a dangerous sexual predator. But upon 10 years of that individual being on probation, the state is required to bring that individual before a judge to determine the appropriateness of that probation. If for some reason they haven't been leveled a level 3, or if their pattern of behavior doesn't require, the judge has the discretion at that point, and we put it there instead of at the initial course because of some testimony and advice from SORB being that some of the most crucial information that they get to do their assessment does come while they're on probation, while they're serving their sentence. So we thought it was crucial to be consistent at the beginning and delay that discretion to ensure that throughout the state, families have the same level of consistency on who they can expect has that added level of supervision.
Okay. And when you say families have that, are you talking about the families of the convicted, or are you talking
I
about?
apologize.
Are
I
you-
appreciate the clarification. Through that our citizenry can expect that clear distinction on who is going to have that added level of supervision, and it's not by judges, a patchwork of did they feel it was appropriate or not. We know that the data shows that if you're twice convicted of 2 felony level sexual offenses, you are extremely likely to be leveled a level 3 sex offender, which is why we're putting that as the requirement for that lifetime sentence.
Yeah, and Mr. Chairman, if you don't
Probation.
mind, almost called you senator, almost gave you a promotion. I
We
apologize
can
for
agree to
that.
disagree on that.
Representative, I know you've been working on this for 5 years, because I recall when you started lifting this heavy lift, and you and I came in here together. And I can only assume that during this process, you did a lot of research and a lot of studying, not only on this, but on the individuals that you were attempting to impact. And I have a DSM-5 on my desk at home. It's the most expensive paperback I own. And have we found, and based on what you said about the twice convicted, is that there have been determinations that this is an issue beyond sexual gratification and some of those things, that some have classified this as a mental health issue, and that there are, in fact, support groups and other types of organizations throughout our communities that attempt to work with these individuals and attempt to get them back into what the mores of the community are when it comes to behavior, especially, and I'll be very biased in this, especially when we are talking about males' attitudes toward females when it comes to sexual drive and some of these anger issues that some of these predators have toward females. Is that not true?
I completely agree, and I would emphasize what the undertone of your statement, which is that I don't think any of us in this, in your committee or the initiation from the House is not to look at a group of individuals and say we want to punish, give an added punishment for the sake of punishment. This is the cusp of this is to prevent victims from happening again, and we know that the data shows by adding a GPS monitor to a certain class of individuals, specifically these dangerous sexual predators, it is a much higher likelihood of preventing that reoffense, which is a service not only to our citizenry but to that individual.
Thank you very much. Okay, we're going to have a few more people testify now. Isabel Otero.
Hi, good afternoon, everyone. I apologize for my voice. It's allergy season, so.
We understand.
My name is Isabel Otero. I am the Georgia Policy Director for the SPLC Action Fund. As everyone has mentioned already, this is a really complicated issue to discuss, and a really serious crimes that y'all are trying to address. We just want to, there's one specific thing that has not been mentioned that we wanted to talk about. The current Georgia law already severely penalizes, sexual-related crimes. The addition of imposing lifelong probation, unfortunately, in talking to our attorneys, they have asked that we talk about how this could result in actually higher recidivism rates for violations that may be unrelated to the initial sexual offense that caused this person to be incarcerated in the first place. As you know, someone convicted for a sexual-related crime will have a more difficult time getting around the community, depending on having to avoid specific locations. They won't be able to get a job very easily. Like, there are different economic implications that could lead them to violate probation in ways that have nothing to do with their original offense. And so our main point here is that this particular issue could increase recidivism rates and reincarceration. And what we would want to see instead is this body focus on treatment and things that Senator Robertson has mentioned that could help prevent some of these issues from reoccurring, rather than sort of seeing some of these more severe impositions on folks, so that we lower recidivism rates and reincarceration. Thank you.
Okay, next up, we'll have Ms. Tracy Alvord with SORB. Certainly. Yep, go ahead and just pass them. We'll send them around. Oh, hang on, we got a comment.
It's not a comment, it's a question, because I keep hearing after their first offense, and the bill that I'm reading, it's got previously convicted throughout, which means subsequent offenses.
You are correct.
Okay, I was just making sure I wasn't missing something.
Thank you, Senator Dugan. Okay. Tracy, please. Thank you.
Good evening. Thank you for having me and allowing me to speak. My name is Tracy Alvord. I am the director of the Sexual Offender Registration Review Board. I have been director since 2010, but I'm also a treatment provider where I've worked with sex offenders for 30 years. So I come not just as an administrator, I come as someone who continues to work with sex offenders actually in a prior practice, and so I'm quite familiar with the dynamics of sexual offending behavior. And so the first thing because, of course, this came from the Parks case. And one thing is when we talk about these things, we can hear them, and it seems like it's very vague to me when you just hear it. So I provide you the first handout on the left-hand side is actually the Parks case. It gives you the details of what he did. And when you have a chance to read it in your nighttime reading, be ready, because this is an individual that got it where we are overturned, where they're no longer on a monitor, and so he is not wearing a monitor, and he is walking in our communities, and he is extremely dangerous. He is an example. So this is a real example, and he's an example of an individual who has 2 sex offense convictions. So this is what we're talking about in this bill. And so I just want you to be able to see that so we can kind of refer to reality of these offenders. When you have an individual who commits a sexual offense, we do have treatment. So the Department of Community Supervision does a really great job. The sentencing judges do a great job. The district attorneys do a great job where once they're sentenced, they're required to attend sex offender specific treatment. They also have a specialized sex offender probation officer. So these individuals are watched and monitored and treated in a particular kind of way. They're given the tools that they need to not reoffend. So you might have a sex offender who takes advantage of this and who never reoffends again. And that's the expectation. So this bill doesn't address those individuals who really take their treatment seriously and make a change and do not go on to molest again or rape again or whatever the case may be. This bill takes into consideration that individual who has been prosecuted, who has had consequences, who's been monitored, who's been in treatment, who's been on the registry, and he yet does it again. So that what clearly tells us is that this person who has disregarded all these things and chooses to do it again and how dangerous they really are. And this is why we know that somebody who has a prior sex offense and does it again despite all that is a very high risk to reoffend. The most robust predictor of sexual reoffense in the research is having a prior sexual offense. So this is why this is a bill worded the way that it is, and so I wanted to put that out there first and foremost. I also gave you a copy of one of the questions has been about the issue of the individual doing their time in prison with this life sentence, getting out and having to be on a life probation, and concerns about this individual being on life probation. What we know is when they're incarcerated and in prison, they don't have access to children or access to women they could rape or access to all these kind of issues. So it's not until they're out in the community that we can really assess, is this person managing their sexual behavior? And so they actually give the opportunity that after 10 years, because when we look at research, if an individual can remain in the community for 10 years without any kind of issues, typically their risk tends to decrease to some degree. So that's why we went with the 10 years. And you can see, because the research, and a lot of people would talk about the research and what usually it starts at 5 years, which I don't agree with. And I don't agree with it because we're watching the trends in Georgia. And one of the reports I gave you is an individual. Another case that comes up a lot is statutory rape. You know, we all worried about the young boy who has sex with an older teenage girl, and now he's classified as a sex offender and on the registry. And oh my gosh, for him to be on life, probation or a sentence. We're not talking about that kind of person. So I give you an example of that. So we had a case where an individual, we classified him. He had a statutory rape, which, by the way, is not always what we think it is because he was 29 and he had sex with a 15-year-old. But he got convicted of statutory rape. We classified him as a level 1. So 8 years goes by, and then he reoffends. And again, this is an individual who's convicted, who had consequences, who had treatment, who had all those kind of things. He goes on and he reoffends, and he molests a 10-year-old at the age of 36. So that tells you that this individual didn't take advantage of managing their behavior, which is what we're trying to address. Now the issue, so just to kind of give you an example, the next example is just kind of a list, because I've been tracking when we get notification of somebody who's sexually reoffended, and that person we have classified already, is really how long in between the first being caught and the second being caught. And I say being caught because we know that risk is an underestimation, because a lot of them are not caught with the numerous offenses that they commit, which is why we're going to talk about the probation part of it in a minute. So when I look at the trends, you can see that 76% of the Georgia sex offenders, this is a small number, we have 61 cases that I am familiar with, 76% reoffended after the 5-year mark, and 56% reoffended after the 8-year mark of those who reoffended. And that's why we're saying the 10-year mark once they're out on supervision. Regarding Merriam's Law, which, by the way, I think that the title is perfect. And I think the title is perfect because, unfortunately, we all know that sometimes when something really bad happens is when we have to wake up and when we have to make changes and do something different. It makes me very emotional. I don't like being part of a system that didn't get it right. That wasn't able to classify this case to make sure. And there is research that shows that the GPS monitor does reduce recidivism. I am finding now that when we did have GPS for life with sex offenders when they're predators, I got notified less often of them reoffending or being caught reoffending. I'm getting more now who are predators who are no longer required to be on monitors reoffending. I think that says something. It's a small number, again, but it is a number for me to tell you that I think that that supports the issue that GPS monitoring is very important, and there's information to suggest that it does help with recidivism. With probation, with the issue around, so SORB, as they said, there's 37,000 something on the registry. I have 4 clinicians who classify sex offenders, 4. So our ability to get through all of these sex offenders in the way that we need to, we just don't have enough people to do it. And so the part that's added that was the most recent substitute is when an individual has 2 convictions for a felony sex offense that is prior to this law going into action, meaning they don't have a new sex offense, which would be the 3rd sex offense, that they be placed on a monitor. And the reason for that is because we know, again, once they commit a second sex offense and are convicted, they're higher risk, and we already know they're higher risk. And I'll tell you, the likelihood of them being classified as a predator is very, very good. So it's not like we're just throwing on monitors on people like it's no big deal. We're talking about very serious, dangerous individuals. We're putting the monitor on until SORB can classify them. I know I'd feel better about that they're on the monitor, and then if they're not a predator, then they can come off. And honestly, what would happen is, because DCS, we want the offender to pay, and I will tell you from my experience in working with sex offenders, when you don't hold them accountable financially, they don't take it seriously. So we want to hold them accountable. If they're indigent, DCS pays for it. So it's not like they're out, so that is not true regarding there's nobody to pay for it, and this individual is going to be in trouble because he can't pay for it. So there is that. So it actually would result in more officers notifying SORB that we have a 2-time convicted sex offender and we need to classify him as soon as possible. I want to know, because right now we have to get all this, so what we get at SORB, we get lists of names. That is it. No criminal documentation, no criminal history. We have to research and get all of that for every single offender. So right now, when I do get it, I try to identify the higher risk offenders so we classify them first. So if I have officers from DCS helping me because we know we're going to put them on a monitor, that part of the bill is going to be really, really helpful for SORB and for the community, because we know that we're at least protected from those individuals, most of which will be classified as predators. With the discretion of the officer when it's not under that. I cannot tell you the number of times that I have a sex offender who takes a polygraph examination who's been caught for one sex offense and has 20 victims. So officers I know feel helpless a lot of times because they talk to me about it, where they don't have the ability to put a monitor until we classify them with these individuals. I do know that if an individual violates their supervision and we're concerned about the risk, and I say we, meaning DCS, which is not we, but you know, if they take them back to court, the judge can then order them to be on a monitor, and the DCS officer will feel comfortable requesting that. We need to give the DCS officers a little more latitude in making these decisions because they have to watch these individuals. They have to feel okay and watch. They have so many people to watch over that this gives them opportunity to watch them, to look at their patterns and tell the treatment provider what's going on or polygraph them about something. So that additional piece with probation having some latitude, I think is very beneficial in my position in thinking about that ability, because then again, if we have an individual we haven't leveled yet, it's the same basic criteria. We just haven't been able to level them yet. We still will level them. So if I have an officer that says, Tracy, you know, we have a guy who has one sex offense conviction, but we know he's molested 10 children. I'm like, send it on to me. We're going to prioritize that case. So we'll get them leveled. But in the meantime, for them to be monitored, because that officer is smart. There's a reason they're a specialized sex offender officer, to give them that opportunity to make that decision. So that's kind of my piece there. I did want to add numbers because I know numbers is a big deal, and it sounds like we're just putting all the sex offenders on a monitor, and that is not true. When I looked at the numbers, so if we go by, because I didn't really know how many sex offenders are currently being supervised, but I just found out it's about just over 11,000, and about 8% we classify as predators. So what that means is that 880 currently on supervision would to have a monitor on them that don't currently. Well, I say that don't currently. They do, actually. 400 and something, I believe, are currently on a monitor. So only an additional 400 and something would be placed on a monitor based on these criteria in the current write-up for this bill. So I just want to kind of give you those ideas of numbers.
Tracy, thank you. I think you had a great review, as well as probably answered and addressed some comments that may have not been completely accurate. I've got a question for Senator Robertson first. You're on deck, Senator Jackson.
Thank you. I appreciate your testimony, and you know, this fell under my bureau before I decided to pop smoke and come up into this chaos. But the deputies that worked for me had specialized training that was provided by the Georgia Sheriff Association and other groups, including CIT training and other things, but advanced training. The officers that you're talking about, the ones that do these evaluations, do they receive accreditation or certain types of training that, like you said, that qualifies them to make these assessments and determinations?
Yeah, so all of my clinicians are experts in the field. And so they actually come as experts, the ones I've been able to hire, and then they receive yearly training about any new research. So if anything new happens, then we add that to our determination how to conduct a risk assessment. But we use the most national-wide risk assessments that there are.
And so the risk assessment tools that you use, are all of these human, or some of these software-based, or any programs that crunch the numbers and make determinations based on, I think the author of the bill used the term data points that are determined from a national standpoint?
So, and that's a great question, because so the Static 99R, for example, which is used nationally, they have created one that's just automatic, which is great, except for one, it's expensive, but two, because we do it the way that we do it, so we look at their entire criminal history, so not just the sex offenses. Associated with risk is violent offenses, domestic offenses, criminal trespassing, things that could be sexual related. So we look at all of that information. Then we also look at their community supervision, their prison behavior. We have guys who are exposing to correctional officers in prison, and that actually in research shows an additional risk factor. We also look at community supervision, their polygraph examinations, their treatment behavior, all that. So to be able to dump that into something to make sense, we just don't think that there's any possible way to do that, unfortunately. So we do everything very personally. This is very different than the Adam Walsh Act, which is tiering, which a lot of people ask about, because there's been, in the media, they talk about, they're given a tier immediately upon sentencing. Research will show that the tier 3s actually are probably less risk than their tier 1s. And so I'd rather have it correct than just to throw out a number out there for people to think they feel comfortable. And so it's very personal. We are very passionate. We want to make sure we get it as right as absolutely possible, which is why we also, the offenders are allowed to give us additional information in case we miss something, and there's judicial review, and there's a legal process that allows them additional legal rights in this process.
Thank you, ma'am.
All right, Senator Jackson.
Thank you, Mr. Chairman. So can you just tell me, how long does it typically take SORB to level someone? Because it seems like, I keep coming back to Miriam's family. It seems like if this person had been leveled more quickly, they would have been on a monitor, and that could have helped. And so do you all have enough resources in order to level people in a timely manner? Somebody testified that it seems that this bill presupposes that you all cannot meet the requirements that are listed here. Is that true? Can you meet these timelines? What do you need in order to ensure that people are leveled in a timely manner so that you don't have people who are on monitors just waiting for you to, quote, get to your job?
So we need a lot more personnel. We have 4 people that conduct the classifications. I have 1 full-time investigator that's paid by the state. We have a grant that provides for 3 part-time investigators. So we're severely understaffed to do this. However, we do prioritize the higher risk cases, and so we try to do those as quickly as possible. Time-wise, so you might have a guy who, and it wouldn't relate to this particular bill, because you might have an offender who has 1 offense and he has nothing else in his history. That can be done in a couple hours. We have a guy we recently did one where the guy has 4 separate sex offense convictions, and he's out in the community. We classified him extremely dangerous. You can imagine his pile of information that we're weeding through to make sure that we get it all, because when we go to judicial review, we have to support everything that we say and everything that we do. And so that case could take an evaluator a week to get through everything. So it just depends on the extensiveness of the case. We've had a case where it's a 1 offense case, but it's so extensive because there's forget what you call it, where there's additional victims who came forward. They just didn't prosecute the case. And when you conduct a risk assessment, the researchers show that you still count those types of cases, even if they weren't prosecuted for those. And so you can get loads of information that was never, necessarily in their criminal history, but it's stuff that they've done that has to be counted associated with their risk to reoffend. So I wish I could answer that question easily. It just isn't an easy
Well,
And
I
and Senator
think-
Jackson,
can
I
I
do want to
just-
add some color commentary that Tracy and Representative Ballinger and I have met to talk about their funding needs in order to help them out as well. Just want you to know that.
Thank you. And I think I'm trying to think more specifically, like from the time that they are released to the community to the time that they're leveled, what's that time frame? So less how procedurally, but, how long can a person walk around before they're able to be leveled is more my question.
So that's a great question. So how we do it, because when SORB started in 2006, they had to create SORB. So it took a year before cases were even started. So they started with a 2,500 backlog from the very beginning. And then they had 3 part-time evaluators and no investigators. So I'm just explaining kind of the backlog situation. So how my investigators do it is first of all, we focus on the high immediate priority cases we identify that has more than one sex offense, whether they're convicted or not of the second one or not. So we try to process that as quickly as possible, but we currently have, I would say, 50 immediate priority cases that my evaluators are working on. And again, if it takes 1 to 2 weeks to complete an immediate priority, and then we have to wait for the board to vote on that case, which is once a month. Not that we can't do, there has been times we've called for emergency meetings because it's such a bad case. In other cases, if we don't know their immediate priority, then my investigators would take, let's say, Hall County, takes all of those cases, goes to Hall County, gets all of the sex offense information from Hall County. But the issue is when you have higher risk offenders, then he's got also offenses in Fulton County, he's got offenses in Bartow County. And so now they start with the main county, but now they're going all over. And so again, the question, so they take a bunch from a particular county, we try to get as many done from that county, and then once the investigation is done, it sits for the evaluators till they can get to those cases. So again, there's just not an easy answer. So they get out of prison, we might have a guy that before he got out of prison, we leveled him, because he happened to be in that selection. We have another guy who maybe has been out for 5 years, and we haven't leveled him.
All right, we're going to keep moving on because we've got a couple more folks to hear from. Tracy, thank you for your testimony. Very helpful. Okay, next, Robert Lepek. Come on down. Smith, that is. I'm going to wave off. All right, we're going to wave you off. Okay, this is Miriam's Law. And I'm very, very proud of Ali, her brother, who is honoring her life and memory along with Miriam's best friend, who've made this part of their life mission. So if you would, sir, please come take the podium and provide us your testimony.
Thank you, Chairman Albers. Also want to say thank you to the other members of this committee that listened to our story early on. Also want to show my appreciation to Representative Saines, who sponsors this bill and has let us work together on it. Also want to show my appreciation to Tracy, who's always been supportive since the beginning of this journey. I would like to share my personal connection with this bill. We've actually bought we've bought purple folders. I've noticed there's a couple of purple folders here. I just asked the committee to follow along with the purple folders that have the photos of Miriam in it. Thank you very much. I'll try my best to be brief, but this all started on the early morning of August 13th, 2021, where Miriam, may her soul rest in peace, was followed home on the way home from work. She was kidnapped from in front of her house, and the very same morning, not long after, was murdered. Very same day, that individual that committed that crime was caught. We saw that his information was released and did a little bit of our homework and saw that he had prior convictions of attempted rape with a 5-year-old and a 7-year-old. We looked into his case prior to sentencing and saw that the judge that sentenced him, the prosecuting office at the time recommended 30 years, but for some reason the judge, knowing his charges, gave him 15 years, where he served 7 and was on parole for 8. From here, we looked him up on a sex offender registry and still see that to this day it says not leveled. We looked into the organization that handles the leveling and the classification of sex offenders and sat down in their meetings where we gained support from Tracy and we learned their process. From here, we learned that SORB currently now still faces a backlog issue, and that is the reason why this individual was never received a risk assessment where he should have been deemed the most dangerous. Excuse me. After we learned this information, we decided to engage in policy initiatives where we wanted to monitor the most dangerous predators in our communities. From here, we also raised awareness on the highlighted issues that you see in the folders. It's within the AJC articles. We've also started a petition that has received 11,000 signatures. And then from here, we've made a lot of friends where we met Councilwoman Keisha Waits, who invited us to the Atlanta City Council, where they created a resolution to push this law as a state law. We also sat with the Fulton County Commissioner Board, where they also gave us full support, where we actually got support from a sheriff who was only showing support for our bill. But this bill is very important to us because, of course, for Miriam's situation, there's a key word that we like to use, which is preventable. If such a bill was a law, we know that Miriam's situation could have been prevented, and we only do not wish this upon anyone else, and if this bill does become a law, it will prevent other tragedies from happening and other situations like Miriam's. So today I'm here to ask support from this committee, and I thank you for your time, for listening, and right here in front of you guys, that's our support system, everyone in that front row. I'm including Mike too, because he's supporting us today. So thank you to you guys as well, and thank you to this committee. If you have any questions, I'll take them, but that is all.
Let me say this. I am confident that right now Miriam is in heaven, and she's proud of you, and we are as well.
Thank you, Senator.
And I'm going to recognize Senator Robertson.
Chairman, I make a motion to pass.
I have a motion to pass. Do I have a second? Second from Senator Goodman. Any further discussion in the committee?
Because there was a comment that was made earlier that we tend to use these violent crimes and pick a person's name to politicize something. And that's not the way I see the names. I see the names as a reminder of stuff that we didn't get done when we should have. And these are the consequences.
Well said. Seeing no other discussion, all those in favor, please raise your hand. All opposed, like sign. This passes unanimously. Congratulations, Representative Saines, Ali, Aaron, well done. Thank you. This meeting is hereby adjourned. I am. All right, meeting hereby adjourned.